Hello, and welcome to part 2 of my introduction to copyright. In the first part of my introduction to copyright, I briefly discussed some modern copyright issues, and then I delved into the history of American copyright, first by exploring the Constitution, and then by discussing the first ever copyright law, the 1790 Copyright Act. Finally, I finished my first part by discussing the 1831 Copyright Act and some of the big differences between that and the 1790 Act which it replaced, the biggest of them all being the initial term length being extended from 14 years to 28 years. Now, what I didn't talk about in the first part of my introduction was this question. Why did the initial copyright length get extended from 14 years to 28 years? This is an important question, and who decides anyway how long a copyright term should last for? And who pushed for it to be extended? Well, the answer to this was actually really easy to find. Various sources all point to one man, this man, for the 1831 extension. His name is Noah Webster. And so why would he want copyright to be extended? For this, we have to get to know Noah Webster a little bit. And so here we go. Noah Webster was an influential lexicographer in early America. This meant that he was a dictionary writer. He graduated from Yale. He was an active pedagogue, which means teacher, and a creator of some of America's first dictionaries. He was a firm believer in secular education and an abolitionist. In fact, some might call Noah Webster an archetypal American citizen. And even this portrait that you see of him here was painted by none other than the Samuel Morse, the inventor of the Morse code. Also, he's commemorated to this day with a statue in West Hartford, Connecticut, in front of a public library. He Americanized some of the English language. For example, he chose the letter S over C in words like defense, and ER instead of RE in words like center. And his name is even carried on through one of the largest online dictionary websites in the entire world, Merriam-Webster.com. And finally, he was commemorated with a United States postage stamp. But the most interesting thing about all this is Noah Webster was not the most influential Webster of early America. No, that title is actually held by his cousin, Daniel Webster. Daniel Webster, a man who rose from a mere House of Representative all the way up to the Secretary of State for 2 different presidents, was far more influential than his cousin Noah. Like Noah, he also gets a statue, but his is in Washington, D.C., and it's way bigger. He gets his own hall named after him at Dartmouth University, Webster Hall, and he was the 12th president-elect for the United States of America by New England. Finally, he also gets not just one postage stamp like Noah, but at least 6 to commemorate him. So, it was a letter from Noah to this cousin Daniel in 1826 that shines light onto why the 1831 Copyright Act extended copyright. This is what Noah Webster had to say. I sincerely wish our legislature would come at once to the line of right and justice on this subject, and pass a new act, the preamble to which shall admit the principle that an author has, by common law or natural justice, the sole and permanent right to make profits by his own labors, and that his heirs and assigns shall enjoy that right unclogged with conditions. Oh. Well, by nature Noah Webster was a wordy man, but what he meant was not that complicated. He basically said this. He didn't like the 1790 Copyright Act. He wanted a new one, which he actually eventually got. And in this new act, he wanted the government to keep their hands off of his copyright. He wanted his copyright to last forever, and he wanted to be able to give it to his heirs or assigns at his own leisure without a copyright term ending. But Daniel Webster had some bad news for Noah. He wrote back, I confess frankly that I see, or I think I see, objections to make it perpetual. And so, with this, the result, as we now know, was an extension of the original copyright by double. 14 years to 28 years, still with a 14-year extension. Yes, it was a far cry from Noah Webster's desired perpetual copyright, but it certainly was a significant extension nonetheless. In fact, this extension was so significant that we should probably take a moment to consider the life of a man in proportion to copyright. And who better to use than Noah Webster himself? Noah Webster lived 84 long years of life. And had he lived all 84 years of life underneath an act such as the 1790 Act, his work would have been protected for a mere 33% of his life. His hard lexicographic work would have only been protected for 33% of his life. You can understand why somebody as intensive as Noah Webster would want an extension of copyright, even if it is just a short bit, because this work that he did was more mathematical than anything else, and he wanted to be able to reap the benefits of his rewards. So, had he lived his 84 years of life under the 1831 Act, however, he could protect his work for a maximum of 50% of his life, which was better, but it was not his dream. No. Noah Webster's dream was this: perpetual property. And that's depicted here in these two pictures. Perpetual, as you see on the picture on the left, meaning it goes on forever. So as long as the United States of America is a country, that's as long as Noah Webster's copyright will last. And the other part of this, property. He wanted his work to be considered property, just like physical property, just like a house. So his Grammatical Institute of the English Language, the American Spelling Book, and the American Dictionary of the English Language could all be bought and sold just like you could buy and sell a house. Everything would be just the same as that. And this was Noah Webster's dream: perpetual property for copyright. And that is not at all what the Constitution or the 1790 Act had in mind. So, we have to understand that this belief, this Noah Webster's dream, will not go away. You have to remember this. Perpetual property will keep coming back. And it's a simple concept to understand. It's property that's bought and sold into eternity by the owner, whoever that may be. And before I finish this introduction, I'd like to discuss one last thing about the 1831 Copyright Act. It also prohibited the reprinting of any portion of any book without the author's permission. So this isn't how it is today. Today, if you wanted to reprint a portion of a professional or an expert, you can use a sentence or a paragraph or a short bit. And as long as you attribute the author, you're going to be able to be just fine with that. It's not against copyright law. But in 1831, you had to ask permission for even a sentence. And so it was no wonder why that in 1870, this copyright revision changed and they removed this reprinting prohibition. I mean, can you imagine going around asking, in the age before the internet, cell phones, telephones, cars, or trains, going across the state or going across the country on horseback or sending a letter to get permission to use a sentence or a paragraph in a book? There's no way that this would have worked out really well, and it clogged the copyright law. And no wonder why it was repealed in 1870. Also in 1870, the newfangled invention of photographs were allowed to be protected under the copyright pool. And there are also other revisions to the 1831 Copyright Act, and they all dealt with international copyright in 1874, 1891, and 1905. The 1831 Copyright Act that Noah Webster pushed into place reigned for 78 years and was not displaced until finally the 1909 Copyright Act came. Now, this 1909 Copyright Act was no ordinary Copyright Act. This 1909 Copyright Act was the watershed Copyright Act in American history. Copyright would never again be the same in American history after the 1909 Act. And it was when I decided to start learning about the 1909 Act that I learned that copyright was a much bigger issue than anyone could have ever imagined.